Professor Porter. We're talking about criminal law. Again, we're talking about defenses, and specifically we're talking about the defense of mistake of fact. Again, where it fits in the course, spent a lot of time talking about different parts of what makes criminal law unique, some of the processes that make it unique, including the burdens and the presumptions and who can do the charging. We talked about parts of crimes, actus, mens rea, causation, the social harm that we're trying to protect against. We talked about specific crimes, and here we're talking about specific defenses. One of the first ones that comes up in the course because it's related so directly with our study of mens rea, our study of intent, is mistake of fact, when the defendant claims at least to have some mistaken belief that relates to one of the elements or the government's proof of one of the elements. Well, it comes back again to this classification, and it's an antiquated classification having to do with specific intent crimes and general intent crimes. We still need to know this for our bar studies, and we still need to know this for the purpose of some defenses, including mistake of fact. Other ones might be diminished capacity or voluntary intoxication, but for our purposes, general intent crimes, the intent relates just to the conduct. Intentionally took, knowingly struck, knowingly possess. Our intention is just as it relates to the prescribed harm. Did I knowingly do something that brought about injury or disability or death? So it's when the intent is really just clearly modifying the conduct or the result, that we really only intend the acts that constitute that social harm. Specific intent crime is everything else, everything that we know, especially from the common law, that the intent requirement is something above and beyond just intending the mere act, the mere actus reus that is part of the offense. So a lot of times it has to do with future acts. Burglary, common law burglary is a good example of that. I'm breaking and entering, I'm knowingly breaking and entering the dwelling house of another, but I'm doing so with the purpose of committing a crime therein, purpose of committing a future act. That's the intent, the specific intent that has to be going on in my brain. Same thing with common law larceny, another property crime, another crime against property, a special motive. I knowingly take and carry away the property of another. That's larceny, but I do so with a specific motive, with the intent to permanently deprive the owner of that property. So that's my special motive. And attendant circumstances, we might have a different part of a statute. You might say, don't endanger the welfare of a minor, and the minor is defined as someone who's 17 years old or less. And whether we have to know that attendant, did I know that person was 17-year-old and left to be able to prosecute endangering a minor? Well, that awareness, knowing that someone is under 17 at the time when you're doing the endangering, that awareness of attendant circumstances could also be an intent that's above and beyond something. And a lot of times we have that specific language that is mentioned in burglary, in larceny, with intent to commit a crime therein, with intent to permanently deprive the owner. So these are specific intent crimes. So if I sort out and sort of classify general intent crimes being the ones that it's just direct modification between the mens rea and the actus, or the result, and specific intent crimes is everything else that it requires a little more, especially these examples or the magic language of with intent to, I can start to see, at least in the common law, how it would relate to a mistake of fact defense. Learning a little more, this is kind of some of the rough, most of those property crimes, like we talked about, larceny, burglary, robbery, they all have they have something above and beyond, so they're specific intent crimes. Same thing with inchoate, and we'll study it in a different video, but just know that your inchoate crimes, your conspiracy, solicitations, attempt, they're all going to be requiring something more by way of a specific intent, because essentially you have less actus involved. You have substantial steps that might be taken in the direction of a crime, but you don't have a full-fledged act that gets you all the way there. Same thing with different statutes. In a common law, we had some frosting that was put on common law murder with willfulness and deliberateness and premeditation. Those require something above and beyond as far as it relates to intent. Some of the general intent crimes that we know, rape, battery, kidnapping, they're essentially just intending the actus, just knowingly engaging in the actus. So they're going to be general intent crimes. So if you're you remember the formulas and remember the definitions is one way to remember how mistake of fact is going to apply. The other way is just remembering some of these classifications. Crimes against property, first-degree murder, inchoate crimes are going to be some of your clearest examples of specific intent crimes. Then, we start to look at and build up, like, what do we need? Obviously, if you start over way on the right side, a strict liability type crime, a general welfare type crime, usually a regulatory measure, not carrying serious, criminal implications, but something, statutory rape fits into this category, speeding fits into this category. Well, it requires no intent. It's a strict liability. It requires no intent. So therefore, no mistake is going to be a defense. If it's a strict liability offense, your mistake, and it can't possibly do away with or impact or affect the proof, the government's proof of proving mens rea at the time. If it's a general intent crime, way over on the left, just intending the act, just intending the harm that the crime is sought to prohibit, we need two things. We need for the defendant to actually believe the mistake, and the jurors need to be able to find that a reasonable person would have made the same mistake in the same circumstances. So it requires a little more. I could find that someone, honestly believed in the mistake they were putting forward, but it's just not reasonable under the circumstances. What they did wasn't reasonable, so it's not going to be, not going to be a defense, particularly to a general intent crime like we talked about with rape and battery and those types of offenses. When it's a specific intent crime, so again, thinking back to that last slide, the property crimes, the inchoate crimes, anything that requires a little something above and beyond, an honest mistake has the possibility of affecting especially that specific intent requirement. If I make an honest mistake about, the house that I'm entering, and whether it's the dwelling house or another, or I make an honest mistake about the property that I take from someone, maybe that does something, if believed by the jury, that does something to impact whether I truly had the requisite mens rea to intend to permanently deprive the other owner of that, or whether I had the intent, the specific intent to commit a crime therein as it relates to burglary. So just an honest mistake is going to be enough to probably get an instruction and enough to put it to the jury, and then the jury, of course, has to find whether the defendant actually honestly held. It's no guarantee. They have to then find whether the government proved each and every element, or does this honest mistake actually create some type of reasonable doubt, create some doubt as it relates to the mens rea element. The Model Penal Code, just to be clear, dealt with this in a little different way, and I think it's helpful to understand it, so I included it in this slide. Any type of mistake of fact that happens, it can be put before the jury as long as it negates one of the four mens rea that's available under the Model Penal Code that's adopted by a bunch of states. So if it requires purposely, knowingly, recklessly, negligently, if that's what's required in the statute, does this mistake impact that? Could a reasonable jury, could they find that this mistake makes it less likely that they did so knowingly, less likely that the defendant did so recklessly, then it could make its way again into a defense and something that's before the jury. Jury never has to find these things. It's just whether we're making that way. So think about the top as common law. If it's a general intent crime as categorized, it's going to be requiring an honest and reasonable, one that the jury is prepared to accept as reasonable under the circumstances, and that's all the circumstances surrounding that mistake. If it's a specific intent crime, one of those that we categorize like our property offenses, our inchoate offenses, first-degree murder, some of those, maybe it's just an honest mistake will be able to impact the mens rea, specifically that specific intent part of the crime. And if it's strict liability, of course, mistake's not going to be a defense. Now we'll read some cases and we'll talk more about something I'm not going to cover in this video, which is mistake of law. Your general rule with a mistake of law is just not knowing, ignorance of the law, or just being mistaken as to whether the law was on the books or whether the law applies to you is usually not a defense. There are some examples when you get the mistaken impression from some other source or some other authority where it might actually contribute to whether you had the requisite mens rea. But for the most part, the general rule is going to be a mistake of law is no good. Mistake of fact, depending on what type of crime you're dealing with, can in fact be a defense. And one of the ones you should consider first in your checklist of defenses right after the government has failed to prove they've failed to meet their